Good afternoon. Welcome to another session of the Deal Doctor Live. It's 1 o'clock Monday. Imagine that. Here we are. Today's topic is general. Communicate, clarify, confirm. And I'm going to start with a situation that occurred recently where an agent wrote an offer, and in the process of the offer, because the buyers wanted to win the offer, because they had lost out on several homes, the buyers said, well, let's go without having inspections. Let's waive the inspections right out of the gate, which frankly is a bad idea unless your buyer has pockets full of money that they can fix a furnace if it's bad, or put a new water heater in. If they've got cash in their pockets, they can certainly go without inspections. But if they're on the edge, if they're pulling money from everywhere possible for their down payment and cash to close, then writing an offer without waiving the inspections is probably not in their best interests. But these buyers insisted. They said, we want to win this offer. We don't want to lose another offer. We've lost enough offers. And so they wrote the offer, and then with a $6,000 earnest deposit, by the way, and then within a matter of hours got cold feet and decided that they wanted to bail out on the contract. Well, guess what? They didn't have the inspection addendum to use where they would go in and do an inspection and find something wrong with the house in order to get out of the contract. In fact, they had no way to get out other than if they ultimately didn't get the mortgage, if they weren't approved for the mortgage. But here they were within 24 hours before they even made mortgage application, and they want to bail out of the contract. So, of course, I get the call, and I said, this is really not in our scope of duties. This is a legal question. If they want to find something in the contract that will get them out and get their money back, they need to contact an attorney, because I don't see any way that they, according to the contract, can get out of the contract and get their money back. I think they give up their earnest deposit. Well, all within this 24 hours comes to light that they never actually turned over a $6,000 check. So now what do we do? Well, according to the National Association of Realtors Code of Ethics, the buyer's agent did exactly what the buyer's agent was supposed to do, and informed the listing agent that the buyer had not delivered the $6,000 earnest deposit. With all of that, the listing agent wisely put the house back on the market. There were strong indications, and bear in mind, I encouraged the buyer's agent to get everything that was being said in writing, in some sort of electronic form, whether it was email or text message. Albeit I prefer email. If I've got to go to court and be a witness with our litigator, I'd much rather have it in an email, some sort of documentation. Very often text messages don't have enough explicit information in it to make it legally binding or to act on it legally. So communicate. If fortunately also the buyer's agent did communicate in writing the nature of the risk that the buyer was taking when they wrote an offer waiving inspections, communicated it and got it in writing, so that the buyer couldn't come back and say, well, we didn't know what we were doing when we wrote this offer that waived inspections. No, you did, because the agent put it in writing they confirmed, they communicated, they confirmed it, made it very clear, and they put it in writing. All the things that you need to do to communicate during the process. Ultimately, the deal's going to go south because the buyer didn't deliver the EMD. Does the seller have a right to pursue them, the buyer, and sue them for a $6,000 EMD? I'm not an attorney, never have been. And by the way, please, some agents are still referring to me and Eric as the legal counsel. We're not the legal counsel. We are not lawyers. If we need a lawyer, we will call our lawyer, Gail Anderson, 5 Star's lawyer. So be very careful of that, because it puts us at risk of losing our license if we don't clarify that we're not attorneys. We are brokers acting in behalf of Greg Carlson and Paul Carlson with their authority, but we're not attorneys. So if I was an attorney in this situation for the seller, I would most certainly pursue legal action if there's money there. They wrote a contract. We don't know at this point what the damages are, if the seller is going to have to sell it for less money or is going to incur costs. But it's certainly something that can be done. But again, in this particular case, the buyer's agent did what the buyer's agent was supposed to do, which was to communicate what the buyer wanted on paper clearly and confirm it with the risks and what they wanted on paper, get it all signed. Okay. We get a lot of questions on this one. When a buyer wants to terminate as a result of inspections or title work or well and septic, if they get back the results of the inspections and they want to terminate the contract, we get a lot of calls from agents who say, well, I sent over a mutual release. Again, from a legal standpoint, a mutual release is exactly what it says. It's a mutual release. It requires both signatures to become effective. What if the seller says, well, I don't accept this. I'm not going to sign it. Technically, the case could be made that there's still a contract in place, which is the reason why 5 Star has, for a very long time, recommended the 2-document process, which is the buyer sends over a termination of the purchase agreement. Buyer hereby terminates based on inspections, provided, of course, they've actually done inspections. Buyer hereby terminates based on inspections, and a second document which is signed by all parties and gives the money to whomever it should go to. For example, in that situation, the buyer would probably get their money back. We have other situations where the buyer or even the real estate agent might be awarded the money based on the circumstances involved. But if you're going to terminate a contract, do it as part of the purchase agreement and then have a mutual release sent over, which provides a hold harmless clause in it, which is very important. But that's the part where you basically fight about the money. Who gets the money? That's the money document. The termination document is a separate document, and in our opinion, you really need to do both to do it the right way. So it avoids confusion and prolonging a contract that should be terminated. Let's see. Can we release an EMD with only an addendum? The answer was no. When we accept, sometimes the money's being held by a title company, and I get the call, and Eric gets a call. Well, what do we do now? Nothing. We don't hold the money. We don't have the power to enforce a contract. If it's being held by a title company, the party's going to have to argue that one out with the title company, and the title company is going to say, you're all going to have to go get your attorneys or go to small claims court, let us know how it turns out, and then we'll release the money. Or give me a mutual release. The same holds true if we are holding the money. If 5 Star is holding the buyer's earnest deposit, we need the same documentation, which is a mutual release or a judgment from the court. Only those two. Now, if a seller doesn't want to sign a mutual release, we do have the option of sending out a 15-day or 30-day letter, depending on the market you're working in, which says if you disagree with this disbursement, unless you disagree in writing, within 15 days or 30 days, again depending, we will disperse this money to the buyer. We will refund the money to the buyer. So it gives them, the seller, 15 days to argue a point that they deserve the money. Bear in mind that the broker, the selling broker, listing agent, are probably having a conversation with that seller saying, you do understand that unless we've got a case here, a real case that we can win, if we go to court, the loser is going to pay for the court costs and so on. So do you really want to take that risk just because you're upset that the house was off the market for 30 days and the buyer didn't get the mortgage approved and was unable to get the mortgage approved? So whether it's us or a title company, the only way under Michigan escrow law that we can release that money is to either have a mutual release signed by all parties or a decision from the court. So, moving on. Sometimes it's handy to, again, clarify and confirm in writing what is going to happen in the event that, an inspection. I got a question last week. Do we have to show inspections? Are we supposed to show the title work to the buyer? Yeah. That's a yeah. Within 10 days, in fact. The buyer has a right to review the title work within 10 days. Again, look at your purchase agreements. You got to read your purchase agreements and see what the options are when that situation occurs. They may give the seller more time. They may just go, you know what, I'm terminating the offer because this appears that there's a mortgage that's unrecorded. A discharge has not been recorded on this particular mortgage that was 20 years ago. How are we going to find that lender and get a release on that? It goes into a lot of things. So the buyer may say, I don't want to sit around waiting for, 2 months, 6 months, 8 months for the seller to be able to quiet the title and give me a title that is free and clear of any encumbrances. So understand that that buyer has a right to have the title work and review the title work. And if I'm a real estate agent working with that buyer, I'm going to have read that title work previously before I send it to the buyer. And I'm going to have highlighted anything that might be a concern or an explanation for anything that might appear to be a concern with the buyer. I review every Schedule B that comes across my desk on any sale that I have, even if I have it as a listing. So I don't like surprises. So I review all of the title work on every transaction. That's just what I see as part of my job. Let's see what else we got. Oh, this is a good one. Are buyers entitled to keys at the day of closing if the seller is going to maintain possession? Again, what does the contract say? The contract doesn't say that the seller is going to turn over keys to the buyer at closing. Does not. The word keys is not in that paragraph. Now, some agents mistake that word possession as to be turning over keys. Well, that seller may say, wait a minute, I don't want somebody, this new buyer walking into my house any time of the day or night. I understand that. However, the new buyer is essentially a landlord for that seller who is a tenant for the next 5 days, 7 days, 10 days, 30 days, whatever it is. And as such, the tenant landlord laws apply. So if that new buyer, who is now essentially a landlord, has to get into that property for an emergency, let's say the basement's flooding and the electricity went out, there's a fire in the attic, whatever, and the seller, who is the tenant, is out of town for a day or two or whatever, that landlord should have every right to access the property in order to preserve his the value of his property. So there's two sides to it. The flip side is there's nothing in the contract. Very often, keys don't get turned over until possession gets turned over. I get that. But legally, the new buyer does have a right to get those keys. In one particular case recently, the buyer thought they were getting possession at closing, but they weren't getting possession for 7 or 10 days, whatever it was. And so there was a miscommunication, a lack of clarity, more importantly, a lack of confirmation in writing about when the buyer was going to get possession, and a clear understanding that they were going to get keys or not going to get keys. Possession and keys are not the same issue. So I always tell people, if there's any question, it has to be on the document. And I encourage everybody to read their contracts, every paragraph, every bit of fine print, because that's the fine print is where most of the misunderstandings and miscommunications occur. Let's imagine for a moment that you get an offer on a property, you're a listing agent, and you counter the offer, and the buyer verbally says, "Oh, that sounds okay. I think I'll make that work." And so you sign as the listing agent. You provide signature lines for the seller on the counteroffer, but you also go down below the buyer's acceptance of the offer, and you put the acknowledgement signature, and you have the seller sign both of those before you share it. Now, let's imagine this. It takes a couple of days for that buyer to get that signed, and he hasn't delivered that back to you. He hasn't sent it through Dotloop or email or anything else, but he has a timestamp from yesterday on it. This morning, you get an offer from another buyer, which is higher for cash, whatever, and you say, wow, this is a better offer. Do you have the right to accept that offer? Well, possibly, because obviously the other offer hasn't been delivered to you yet. Therefore, it's not, in effect, it's not a fully executed purchase agreement. But So the seller decides that they're going to accept the second offer and rescind the counter offer that was delivered previously. Does anyone see a problem happening? Yes. Well, the fact that they had actually signed, the seller had signed the acknowledgement for the buyer's receipt and acceptance of the counter offer now puts it in a whole new ballgame. Now we've got two buyers who have fully executed purchase agreements, and if you go to the timestamps, it's clear that the seller had accepted the buyer's acceptance of the counter offer, or acknowledges the buyer's acceptance of the counter offer prior to getting the second offer. And the only answer there that we can give is lawyers. I mean, this is not something we can enforce. This is not something that we can take care of. It's ultimately going to be an interpretation by the lawyers as to whether or not there was a fully executed purchase agreement in place before the second offer was accepted. What else? We're getting a lot of questions about mineral rights. In fact, I think there was one last week going back to 1947. And the question is that still in force? Well, I don't know. I would say that if a seller even suspects that at one time the mineral rights may have been sold off or leased or an option placed against them, they need to do a deep dive into the abstract of title to find where that is. It's not going to show up in a regular title search. It's going to cost more money. It's going to cost, it's going to have to be a specialty title company that will get involved and try to find that mineral rights if it's been recorded. Now, the reason we're seeing a lot of it now is that there are certain areas of our state along the West Coast area which are being purchased for fracking purposes to go in and conduct fracking and suck natural gas out from under the earth. There are some areas that are looking for oil well drilling. And so when you get involved in the questions of mineral rights, the first question that I hear most often is, well, does that mean that they could put a derrick, a drilling derrick onto my property? And my answer is, I don't know. What does the contract say? The option or the lease or the sale of mineral rights, whatever document it is, does it say that they can bring equipment onto the above grade portion of your property? Now, having been in the oil patch business back in the 1980s, I know that drills can go down and spider drills can go out very long distance, half mile or a mile, to other properties and suck oil from the oil aquifers, if you will. I don't know, it's not exactly the right word, I know, but those pockets underground where there is oil, they can actually pull that without ever getting near the property, without putting an oil derrick on it. So when you get into questions of mineral rights, be sure to get a good attorney to review any documents that might be lingering out there that could cause a problem later. Again, communicate. Try to find out what they know. What did Grandpa sell these things off or give an option at some point back in 1947 that renews automatically. Again, you got to dig into it, and sometimes it means that they're going to have to hire a specialist to do that. So, whenever, and one final note about communication. Texting is great because it's convenient, it's handy. You can kind of get back to one another whenever you're available. It can be really fast or it can be really slow. One thing it doesn't do very well is get into the details, doesn't dig into the weeds. And that's really important. When we are constructing an offer for somebody, we really need to have a very clear understanding. Email does a better job of that. A phone call with an email reiterating what you've spoken about before you write an offer is probably still the best way, so that you know and they know what the risks of, for example, writing an offer, waiving inspections, what the repercussions of that are. So again, always focus on knowing the purchase agreements, knowing the documents that you are working with, review them carefully, communicate with your clients, whether it's a seller or a buyer, clarify. Ask as many questions as it takes to get a clear understanding of what they want, and then confirm it by putting it all in writing. And that's probably the best way you can stay out of trouble and stay out of courtrooms. So I hope that's been helpful. Any questions? No questions.
Just a comment by Joanna Lasser. It was 2 minutes ago. She said, I've had this research before. I posted the affidavit and sent it to you for sellers to sign off on these rights. I don't know what that's in relation to. It came in 2 minutes ago.
Oh, okay.
So
I'll contact her off screen. So I hope that's been helpful. Thanks for joining. See you next week.